In this video, we're going to talk about the grounds for bringing a challenge to a will. The first ground that we're going to talk about is forgery. Forgery usually involves a fake signature or a trace signature. By fake signature, I mean a signature that's been copied by hand, and also we have cases where a signature is traced by using a light box or a lighted window. The second ground that we're going to talk about is manipulated wills. The two issues that come up in manipulated wills are erased names or crossed out names and replaced pages. In erased names or crossed out names, it's unclear if the names are crossed out before the will was made or after the will was made. And it makes a huge difference because if they're crossed out after the will was made, they're invalid. When dealing with replaced pages, there are allegations that staples are taken out and new pages are put in. This is really a question of fact. Just because staples are taken out, that does not mean that the will is modified or that new pages are put in. But this raises enough of a question of fact to look at the will and figure out why the pages were, if the pages were taken out, or why the staples were taken out, and so on. And this is something that will be addressed by the court if it looks like the staples are taken out. The third ground that we're going to discuss is lack of capacity. As people get older, they get afflicted with health conditions that affect their capacity to make financial decisions and to make wills. Those conditions are usually dementia and Alzheimer's. So when we look at the medical records and see that the person who made the will is afflicted with those conditions, we'd have to look into the situation and see whether or not those underlying conditions affected their capacity to make wills. People who make wills when they are sick sometimes tend to be strongly medicated, and this often affects their capacity to make a will in a major way, depending on what the dosage of the medication is, what the medication is, and what the strength is. So we really need to look at the medical records and see what the medication is to determine whether or not the person had the capacity to make a will at that time. The fourth ground for a will challenge that we're going to discuss today is fraud. There are two kinds of fraud that we deal with. The first one is lies about people who should be in the will, and the second one is lies about the will itself. Lies about people who should be in the will means telling the person making the will that they should exclude their friends or relatives for a reason that is made up or exaggerated. Lies about the will itself happen when the will is slipped to the person making it under the guise of a different document, such as a health proxy or Medicaid authorization or insurance form. The fifth ground that we're going to discuss is undue influence. Undue influence means pressuring someone to make a will in a way that in the end of the day they have no choice but to make. When allegations of undue influence come up, the person who is accused is almost always a person whom the person who died depended upon. So they will need to offer some explanation as to why other people were left out. The sixth and the last will challenge we're going to discuss today are missing will formalities. Every will needs two witnesses that are present when the will is made and needs a declaration by the testator that this will is their last will and testament. Wills made by an attorney usually have those things because an attorney supervises the will, but wills that are made by people by themselves sometimes lack witnesses or lack a declaration, making it potentially susceptible to a challenge of not having formalities. To sum up, we have gone over the most common will challenges presented in the surrogate's court. If you're involved in a will disagreement, give me a call and I'll be happy to talk to you and give you a free case evaluation.